My name is Isabella Becerra, and we are arguing for respondents.
My name is Campbell Park. We are both juniors at Greenwich High School, and our teacher is Erin Hole.
Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
No, the Equal Protection Clause of the 14th Amendment does not prohibit affirmative action. This clause restrains the government from participating in any action that discriminates against and that treats groups differently. There are three classifications of this clause that are used to review relevant government affairs: rational basis review, intermediate scrutiny, and strict scrutiny. When it comes to race-conscious government actions, the activity must pass the standards of strict scrutiny. To pass this review, the government must prove that the legislation is not only a compelling government interest, but also necessary to further this interest. In Regents of the University of California v. Bakke, the Supreme Court struck down a quota system for affirmative action, however upheld race as a factor in college admissions. In Grutter v. Bollinger, the Supreme Court decided that diversity in higher education was a compelling interest, which upheld affirmative action. This compelling interest was later reaffirmed in Fisher v. University of Texas 1 and 2, which makes it clear that a precedent has been set, one where the Equal Protection Clause allows affirmative action.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question number 1?
The Civil Rights Act of 1866 stated that all citizens of the United States shall have the same rights across the country, with no regard to race or previous conditions of involuntary servitude. It says that all citizens are to have full and equal benefit of all laws in proceeding for the security of person and property. However, due to the oppression of slavery, those of African descent were not benefiting equally to whites. The Equal Protection Clause would ensure that everybody are equal under the law. For everybody to be equal and benefit equally, something needed to be done to boost the socio-economic status of recently freed slaves, as the wealth gap between the whites and blacks was so wide. The Equal Protection Clause supports affirmative action as it is a way to help previously disadvantaged groups so they can benefit equally under the law compared to their white counterparts. Another piece of legislation passed during the 1860s, the establishment of the Freedmen's Bureau, ensured this part of Civil Rights Act was fulfilled. The Freedmen's Bureau made it possible for formerly enslaved persons to benefit equally under the law for the security of their person, as the organization helped them gain access to land, healthcare, and other aspects of life that whites would have been able to acquire without the help of the federal government. This same principle is being reflected in society today with affirmative action, where minorities are being slightly guided in order to benefit equally from society's opportunities, such as higher education.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
Segregation is still extremely present in the education system and districting of schools, which is why the same argument would work in current society. After the Civil War, despite having the same status of citizenship as whites, blacks did not have the same privileges within society. Blacks were often subject to redlining, where they were refused loans because of their race and their neighborhood, which often consisted of other minorities. This made it hard for minorities to move, resulting in some communities being heavily concentrated with one racial group. The effects of redlining and other discriminatory practices are still seen today, especially with the districting of schools. When areas are concentrated with strong minority populations, it is reflected in their school systems. This leads to some schools being predominantly white, while other schools have a much larger minority population. There is a connection between the racial makeup of a school and its funding, and usually the schools that are made up of more minorities are the ones that struggle. This was seen in North Carolina, where public schools enrolled more black students and charter schools enrolled more white students. The state legislature cut education funding by about $700 per student from 2007 to 2012. But from 2013 to 2015, they doubled funding exclusively for charter schools, leaving the public schools to struggle. Although it may be unintentional, many schools are still segregated today as a long-term effect of racial discrimination. Had it been deemed constitutional in the 1860s and 1870s, race-conscious legislation would still be constitutional because of persisting effects of slavery, which keep minority groups, especially African Americans, at a disadvantage.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserved certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
The framers of the 14th Amendment would have agreed that members of other races deserve the same privilege. Their intended goal was to ameliorate the effects of discrimination caused by slavery that still affected those of African descent after emancipation. However, more recently, racial groups other than blacks have been discriminated against. Race-conscious privileges are meant to act as a remedy to prejudice against all races, not only of those of African descent. Asians have suffered discrimination in instances such as Order 9066, and Native Americans have also faced inequality with the Trail of Tears in residential schools. To ameliorate the effects of past discrimination of all minority groups, it is necessary for them to receive certain race-conscious privileges, which the framers of the 14th Amendment would have agreed with. John Bingham, a leader in drafting the amendment, wanted to assure that the constitutional change would guarantee equal protection for any person, no matter whence he comes, or how poor, or how weak, how simple. The main goal of the 14th Amendment was to provide equal protection under the law for everybody, especially of those of African descent, as a way to move past the institution of slavery. The same principle would be applied to other racial groups who have also faced discrimination. Discrimination against racial groups other than blacks may have not been as prevalent at the time that the 14th Amendment was made, but it is prevalent now. In Hernandez v. Texas, the court declared that the 14th Amendment, specifically the Equal Protection Clause, applies to not only whites and blacks, but all other racial groups. If race-conscious privilege were limited to only blacks, it would marginalize non-black racial minorities, which would have gone against the framers' intent of the 14th Amendment.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
It is difficult to determine what the framers would have thought about affirmative action policies that benefit people based on sexual orientation or gender identity. Nonetheless, the Equal Protection Clause of the 14th Amendment does state that every person should be equally protected. If numbers show that the ratio of marginalized persons to the overall population is considerably imbalanced, an institution should always evaluate its policies and admission system or hiring processes to guarantee that they are not hurting or discriminating against any people of any sexual orientation or gender identity. However, marginalized ethnic groups and racial groups needed and still do need remedies for the robbing of their natural and political rights throughout history. While LGBTQ+ persons are discriminated against, people of color still suffer from political and economic oppression. The effects of institutionalized discrimination against their ancestors have been long-term, while people in the LGBTQ+ community are not facing similar effects, as they have not faced economic or political oppression to the same extent as racial groups. Foundationally, affirmative action and other similar programs, such as the Freedmen's Bureau, are race-conscious because they are meant to ameliorate the vestiges of systematic oppression. The main priority of the 14th Amendment was focused on racial groups. Both the modern-day interpretation of the 14th Amendment, with the LGBTQ+ community as minorities, affirmative action could be applied to this group.
Does Brown v. Board of Education, 1954, prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
Brown v. Board did not prohibit race-conscious affirmative action. Brown specifically denied the ruling in Berea College v. Kentucky that upheld a Kentucky law requiring Berea College to stop using racial preferences in admissions. Brown claimed that the Berea case incorrectly caused a termination of Berea's race-conscious admission policy. Brown ultimately ruled that it is unconstitutional to separate students based on race. Segregation violates the Equal Protection Clause and deprives the children of the minority group of equal educational opportunities. Universities like UNC, which have race-conscious admissions, honor Brown's legacy by unifying students with different backgrounds. Affirmative action is a way to hand minorities educational opportunities so that they can eventually obtain equal societal status of those whites. As Brown emphasized, one of the intangible considerations that makes for greatness in a school is the ability of a diverse student body to engage in discussions and exchange views with other students. While Bakke deemed quota systems unconstitutional, it was the first case to mention diversity as a compelling government interest. Grutter officially declared this, emphasizing the fact that affirmative action was deemed constitutional using the strict scrutiny test under the 14th Amendment. and parents involved. A majority of the justices on this court confirmed this point by concluding that schools may implement racial discrimination measures to achieve Brown's purpose of equal educational opportunity and to promote a diverse student body.
In 2003, Grutter observed that, quote, 25 years after this case, the use of racial preferences will no longer be necessary to further the interest of proof today, end quote. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Once America is post-racial, racial preferences will no longer be needed. However, the country is far from being post-racial, especially in the education sector. When looking at both faculty and students of higher education schools, only 1% of R1 institutions are racially representative of the country. R1 institutions, which include all of the Ivy League schools and other prestigious universities, are the best research universities in the country. Many of these schools tend to be more selective with admissions, and without affirmative action, these schools would struggle more than they already do to obtain a diverse student body. As mentioned in a previous question, many communities tend to be concentrated with minorities, resulting in their school systems being underfunded. Students in these systems will not be able to compete in a competitive applicant pool as they do not have the same privileges as students at well-funded, predominantly white schools. Thus, if we end racial preference in college admissions too early, minorities will still struggle even more getting into competitive schools, ultimately hurting their mobility in life. Furthermore, there will be a point in time when affirmative action proves to be so effective that it finally ameliorates inequality and the necessity for racial preferences. However, institutions will have to constantly evaluate their student body to make sure that this is the case. So if we ever were post-racial and affirmative action is ended, its presence would continue to linger and still have an impact on admissions.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent decision of stare decisis in Dobbs v. Jackson Women's Health Organization.
The case of Dobbs v. Jackson Women's Health Organization went against the principle of stare decisis that has been decided in Roe v. Wade. The Supreme Court chose to go against what was previously decided, and as according to Justice Alito, the Roe v. Wade decision had been egregiously wrong. However, the decision made in Grutter v. Bollinger is not fundamentally wrong. Thus, the court should follow the principle of stare decisis. Roe v. Wade's decision was declared wrong because it was made on the basis of the right to privacy, which is not explicitly stated in the Constitution. However, Grutter has been decided based on the Equal Protection Clause of the 14th Amendment, which calls for equal protection for everybody under the law, regardless of race. By using strict scrutiny under the Equal Protection Clause, the court declared that diversity was a compelling interest. Therefore, upholding Grutter v. Grutter, diversity has been proven to foster a stronger learning environment as it enhances classroom dialogue, breaks down racial stereotypes, and provides students with different perspectives. Hence, the Supreme Court should follow the stare decisis set in Grutter v. Bollinger, as it has been adequately proven that under the 14th Amendment, diversity in higher education is very much a compelling interest of the government.
If the court declines to overrule Grutter, can the plaintiffs prevail?
Yes, the plaintiffs could prevail. While the court may not strike down affirmative action, they can narrow its scope and uses of it. An example of this was seen in Regents of the University of California v. Bakke, where a racial quota system in college admissions was struck down, but the idea of race as a factor in admissions was upheld. The plaintiffs could also seek change in a different way, such as going to state legislatures. This has been seen in states like Michigan. In 2006, the state of Michigan passed Proposal 2, putting a ban on using race, ethnicity, or sex as a factor in public employment, public contracting, and public education. However, public universities in the state are struggling to maintain a diverse student body. After the ban called by Proposal 2, the University of Michigan had to completely restructure its admission system to try and achieve diversity. This included spending more money on hiring staff and creating programs that would hopefully reel in minority students. However, the program has not done enough. According to University of Michigan's amicus brief, Black undergraduate enrollment was 7.03% in 2006, but had declined to 3.92% by 2021. Across all of the University of Michigan campuses, the overall number of students from underrepresented groups has reached the same percentage since before Proposal 2. However, this is after 16 years and a lot more money spent on resources to try and achieve a diverse student body. Ultimately, if the plaintiffs do choose to go to the states individually, they will only force colleges to create brand new systems to try and achieve the same goals as affirmative action, yet without being able to call it affirmative action. The plaintiffs would be doing more harm than good, as colleges would have to focus their resources in areas that are more complicated and expensive than they have to be, and the simple solution to this problem would be upholding affirmative action.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
To answer this question, it is important to review that Grutter upheld affirmative action with a basis of racial preference promoting diversity, which is a compelling government interest. Justice Sotomayor and Elizabeth Prelogar, the Solicitor General of the United States, discussed that what would happen if Grutter was overturned. Prelogar agreed that if this were to happen, that they're reducing underrepresented minorities and depriving others who are not there of the benefits of diversity. Reserve Officers Training Corps, or ROTC programs, are offered by a lot of private colleges and universities, including UNC and Harvard. In 2019, about 29% of Black officers and 32% of Hispanic officers received commissions through ROTC. ROTC has been the main source of minority officers. For our military leadership, racially diversified ROTC programs at elite universities are especially critical. In our current society, it is clear that if Grutter were to be overturned, many universities' minority numbers would drop. In conclusion, if this were to happen, the pool of applicants at universities to the military would be restricted. To try to achieve these diversity goals without racial preferences, military academies have investigated other colorblind alternatives, such as socioeconomic considerations, but West Point military academies found that doing so would result in more white men enrolling in the academy. Also, a top 10% plan, for instance, wouldn't work because the service academies must select candidates from a pool of applicants across the country and must also give consideration to and value other qualities, or the whole person concept.